Hello, everyone, and welcome to the Private Investigators Association of Idaho educational webinar. And today we're going to talk about retainer agreements and why they are vital to our line of work. And our guest speaker is Matt Schultz. He's a member of the board of directors and also our sergeant at arms at the PIAI. And Matt has been kind enough to offer up this webinar and also offer us a template which we can use and adapt to our own businesses. So I will be monitoring the chat room. If you have any, Matt, how do you want to answer questions as we go along, or would you prefer to wait to the end?
If somebody has a question, they could put it in the chat and we could stop where we're at and go from there.
Okay, cool. All right, so I'll be monitoring the chat room. So without further ado, let's rock and roll.
Awesome. Well, I appreciate everybody coming in here. And, today of all days, I mean, it's raining. We're indoors, at least here in southern Idaho. Um, and one of the most important things that we have as private investigators is being able to provide quality service to our clients. With that being said, we need to lay out the stipulations of how our services get provided, as well as, you know, expected outcomes, the budget that goes with it. And a lot of the concerns that people have is, retainers, whether or not to accept a retainer or, what'll happen with the retainer if the job isn't done or the client cancels. Not just that, but also, we have worry about reviews. Negative reviews can definitely hurt a business, and sometimes negative reviews come from people that we do an investigation on, or just because the outcome's not as expected. So when it comes to a agreement or a contract, you want to make sure that everything is laid out and all the expectations are met with your client. So what I'm going to do is I'm going to go ahead and start sharing my screen and we'll go ahead and dive into this. I don't think that this will take more than roughly 30 minutes, maybe 40, 45-ish. During this presentation as well, if you have questions, please go ahead and announce in the chat if you have a question. Pat can stop me along the way as we go, and we'll try to answer those questions. Now, I'm not a pro when it comes to doing the contract type stuff. However, I like to think that I've got a contract that suits the needs of a private investigator. Removing the contract mass amount of pages, not knowing what goes on there. I went from a 14-page contract a couple years ago to a 7-page. Now, literally, I'm at 2.5 pages uh, of contract that gets initials and signature at the end before any job is done. And we'll go ahead and just dive into this right now. And I'm going to go ahead and share my screen here. Um, so let me know when you guys see the screen.
I can see it.
All right, perfect. So what we're going to do, give me just a second. It was full screen, but apparently it's not going to be full. Is it full screen for you guys as well?
Looks full to me.
Okay, perfect. Um, so, as I said, my name is Matthew Schultz. I'm a private investigator and a certified private investigator. I'm on the board of directors for the Private Investigator Association of Idaho as the current acting sergeant at arms. So to get started in here, the retainer agreement, what it is, it's a contract between you and your client, all right, that dictates and stipulates services that's going to be rendered on this. One of the first things that you got to put onto the contract at the very beginning, obviously, is who is going to be involved and who's going to be signing the contract. So the agreement needs to be able to display all the parties involved in the agreement. In this case, I have two. I have Mr. Joe Dirt here at 123 Main Street, USA. And of course, a contractor, for the purpose of instruction. I'm using an actual snips from my contract that I use. Now, I'm not saying that yours has to be verbatim to what I use, but the contract itself has been viewed over and mulled over by two separate attorneys for me that have stated, that this is actually very much suffice for what we need it for. So one of the first things, always make sure that you have the client information down and make sure it's correct. And of course, as a contractor, make sure that you as a private investigator, you have all of your information there. This isn't only important for legal purposes, but also for the client. So they always have your contact information, how to get hold of you, with your physical address to meet you. Sometimes you can even, customize it, add phone numbers in there, but the phone numbers, it's optional, obviously, for your own personal contract. Now, the purpose of the agreement, as stated, it needs to inform what exactly the agreement's going to be about. And with this, again, you're going to have the parties that are involved. Then you're going to have the date of the agreement creation. It's not always the sign date. So you may create an agreement with somebody, and then a week later they want to go through with it. So the date might be off from the day that they sign it with the date of creation. The date of creation is when all the details are there and presented by the client, and we'll start getting into that as well, that you can lay out. And of course, the purpose of the agreement. So as you can see on the bottom line of the agreement here, or on this little snippet, after April 2024, we're putting in there that's regarding the provisions of private investigation services by my company. You want to explain in that first little snippet what the purpose of this agreement is. It doesn't have to have the details because that's going to come later as we progress. Now, the questions come out from a lot of people in regards to how do you get an upfront retainer? All right. Well, you stipulated in the contract. One of the first things that people like to see is how much is it going to cost? This makes it simple for you. It makes it simple for the client. And should it have to go to court, it also makes it simple for the judge and whoever else might look at it. In this case, all right, you always want to list the amount to retain the services. Now, with this, okay, you can see in there, I have $3,500 for 35 hours of service. This averages out to where it's $100 an hour, but that's not my rate. That I'm using that as an example. Whatever your rate is, make sure you have the proper information in there. Then you're gonna explain to them on this part here, and it's important whether it's going to be refundable or non-refundable. I personally, I do a non-refundable retainer. Okay, I mean circumstances can change for people, and that's fine. But we'll get into the meat why I do non-refundable versus refundable that a lot of people use as well. And we'll go into that as well when a client tries to use that against you. Then you want to always explain how the retainer is going to be used. So in this case, okay, the retainer is going to actually be used to cover the initial costs and expenses that we expect to be associated with the investigation that we're going to be doing. And this is important because if you don't explain what your retainer is used for, that can be used against you, and you can either miss out on money, or you do the services, find what you need in the first hour, but you planned out ahead of time for multiple days on it, not taking other jobs. Now the client wants money back at sometimes, and that's going to be normal. But again, we're going to get through as we progress and explain a little bit more in depth on that. Now, client initials are always important on a contract. If your client doesn't initial to a section that you've explained to them, they can always say they didn't understand it. And if it was something to be disputed, like if they do a chargeback on the credit card or they make a dispute, you need to show that they recognized what this was, they initialed it, as they work down on the contract, and then towards the end, as long as they have a signature as well and the initials are theirs, you'll win most cases if a dispute does arise, or even if a chargeback arises. Now I don't get many. Okay, I'll probably get a person that tries to get money back maybe once every year, to 14 months, give or take. But it's not that often that this happens, but I do get kind of picky on the clients that I take. So then we're going to go down to the expenses. Again, you'll notice there's a spot next to the number 2 up there. All right, this is also going to be important for the initial because the expenses that we have, a lot of investigators are too nervous to be able to put out what expected expenses are. So with that being said, you always got to let them know, them being the client, if it's going to be applicable and if it's agreed upon prior. And to be able to get it verified and agreed upon, you could do it via email, you could do it via text. As long as you have communication with the client, and explain the circumstances, then you could start getting in here. Travel expenses are a big one that we have here. I personally have a policy that if I go out more than an hour from my location, and especially when it starts nearing that 2 hour mark from my office location, I'm going to charge them for lodging and meal expenses because I'm not going to spend a 14-hour day, to drive out, do a 10-hour surveillance or an 8 hour, whatever the case is, and then have to drive back for 2 hours. So you're going to want to let them know ahead of time what it is. And of course, this covers lodging and meal expenses. And the most important, a client initial. So you need to make sure the client is fully aware. And it does look like we have a chat here. Let me see. Okay, so James asked why I do a non-refundable. We're going to get to that, James, and it'll be explained when we get to the refund section. Okay, and once we get there, you'll have a better understanding of that as well. So moving on the, oops. Yeah, so continuing on, okay, with the expenses here. We have mileage reimbursement. Okay, I charge miles from the moment I leave my office out to where I got to go and following the individual. Now, I have a policy and something I give as a courtesy to my clients personally, uh, that they get the first 20 miles outside of my office for free. But if there's other mileage that's not expected, then I start charging them for that. And then we have miscellaneous expenses such as equipment or communication type of things. Um, if you need a special type of camera, feel free to have the client know that you need that camera and have them buy it for you. Okay, most clients, if they want to get a resolution and you stipulate it in the contract, hey, I don't have this piece of equipment, but we might need it, then the client will probably go on Amazon, get it for you or wherever they can, and they usually fund it. And I have not had an issue with that. Um, However, you don't want to abuse it, and that camera you've been waiting for 2 years, you don't want to go have the client spend a couple thousand to get you a camera just because you want it. Make sure that it's need specific. And then, always again have the client initial. This is all part, like I stated, within the settings there. So underneath the expenses, I have these listed there for the client to always know and understand before they initial it. Then you always want to make a statement underneath your expenses that it needs to inform of the upfront cost and how the client will know. In this case, you want the client to know if you're going to give them an itemized list of what's needed, or if they want you to purchase it ahead of time, give them the receipts, give them the statement, and see if they want to proceed with it prior to even purchasing anything. But you always want to make sure that the client's aware of it. And, you stipulate that in your contract, this will protect you. And again, making that statement directly underneath the expenses will have the client be reassured that whatever you get is going to be in line with what they approve of. Now I'm not seeing the chat bar anymore, Pat. So if you can keep an eye on that, please. Oh no, there it is. Okay, I got it. Um, so now we're going to go to the services. This is the meat and the potatoes of everything. All right. In this case, we're going to want to let the client know what the services are going to be provided. You're going to explain the terms of the services as well. So if you get too broad and say, I'm going to conduct surveillance, and you say, I expect it to be 10 hours, or, like I have here, and it's something that might need more, you need to let the client know, hey, I'm going to put 10 hours down, but it might be more depending on the need. But again, you're going to communicate with them and list the services that are included with this contract. All right. And again, always have the client initial it. In this case, services can be from locating somebody, obtaining a criminal background on somebody like Jerry Seinfeld, or, surveillance on Joe Dirt's wife's cousin Bill Mudpuddle. Whatever the case is, you need to put it down there and what the expected outcome of how long it'll take you to conduct those services as well. Now, location. This is important on every contract because everybody wants to know, one, where you're going to start, make sure you understand where you got to start at, and be able to move from there. Now, something that I've kind of toyed with off and on with the location portion of things is I always start the primary location at my office. All right, because that's where we're going to initiate.
I'm gonna get my blood pumping on the drums.
All right.
All right, somebody was talking there. Um, so, with the location aspect, if you have an address you're going to start at, say, I'm going to start at this apartment complex, and list locations if it's multiple. You always want to let the client know that you understand that these are the locations that I'm primarily going to be at. Or in this scenario, okay, as you can see on there, I just put that, my address for my office. However, investigations may require that we conduct operations in other locations as necessary. Let me see here. I just got another message pop up. No problem, Claire. Thank you. So again, that goes with secondary locations as well. If you add them to it, you always want to put them inside the location section so the client's fully aware of where you could be expected to start, and they know that you understand their need and understand where everything may be taking place. You can even add times in there. So if you're going to be at a location between these times, add it in the location section. So then we're going to go ahead and move to the fee agreement. So again, we're going to get into here and start talking about finances with the client. Okay. With the fee agreement portion of your contract here, the agreement needs to be informed of these fees once again, because you need to keep reminding the client and having them initial as you go down that, hey, this is what the fees are going to be used for. So you could remind them you're going to pay $3,500 and how it's going to be covered. Okay, in this case, the fees shall be payable as per payment schedule specified in the agreement. So again, if you go back up to the services and you say 10 hours, make sure they understand they're paying for 10 hours. And then, you also want to set the condition of the payment and termination terms as well. So in this case, all right, you want to express to the client that if their payment isn't received by a set time, that you have to cease operations on the case. Okay, not necessarily stop the case, but you might say at the 10-hour mark, you paid for 10 hours. If you want us to continue on from there ahead of time, let us know before the shift and give us permission to do so. Otherwise, if I don't hear from you, we're going to go ahead and stop our service from where we're at the 10-hour mark and just continue on our merry way. And don't be afraid to let your clients know this, because they need to understand that, one, our services aren't free, but two, that you are looking out for their interest too, and they understand how many hours you're going to produce for this. Now, not just that, but like for me, and Carolyn can testify as well, because she's worked with me before. Um, you know, if I'm on that 10-hour mark and I see that I'm on the subject and things are happening, I might stay that a few extra minutes because I want to get what's needed. I may not even charge the few extra minutes because to me it's worth it. but if it goes over that 15-minute mark, 20-minute mark, then I'll start, texting the client, hey, I'm on her right now. Do you want me to continue following this individual, or do you want me to cut off? And again, client initial, always important to make sure your client understands, because it's the moment that they don't initial something that's important for the case, that'll be their clause to get out of the contract. That'll be their clause to file a dispute if they do. And it looks like we have a few more chats here. Let me see. Okay. So moving on from here, we're going to go ahead to the no refund policy. So James, you asked about the no refund and why the no refund. Okay, for my company, I do a no refund policy. And the reasoning in there is because I make it clear in the terms of on the refund itself. So usually if you have a contract and if you want to offer a refund, that's up to you. But different stipulations come in there. Some will say, if you don't contact me within 24 hours prior to the service, then you won't get a refund. But if you contact me 24 hours prior to the service, then I might consider it. Okay. In my case, I don't do a refund, and here's why. Because once work is commenced with me, there will be no refunds issued for any reasons, included, but not limited to, changes in circumstances, outcomes, or the client satisfaction. And this is important because a lot of times we're out there busting our hump to be able to get the evidence needed. And if we don't get what the client expects to happen, they can go around and say, well, I want a refund. You didn't do what you said you would do. Well, guess what? I was out there. I could provide you hourly integrity videos. You're going to pay for my service and not try to cheat me out of it because you didn't get the expected outcome. Now, prioritizing notations is important as well. All right, because you want the client to know that, everything that you do is going to be of importance. So in this case, I'm setting out a time and I'm going to schedule that time. I'm not going to have any other cases that I'm going to take during your block. So the burden associated with the dedicating the resources, time, and personnel to the investigation is really significant. I mean, especially considering that other cases may not have been scheduled during that time, is going to be important as well for the client to understand, because it causes an undue financial strain, not just for us as a private investigator, but there could have been a case that I could have made $5,000 on, but you're only paying me $1,000 on, but yours is in that slot, so I didn't put that $5,000 there. That refund's not going to come to you because I planned the day out ahead of time, and now it'll be too late to put another case on there without the client, the clients communicating and all that. This also is important if you have other staff members with you or you're paying other investigators, because they need to plan the day. And if you don't have something else to cover for them or to put them on, that takes them out of the work for that day that they were expecting that money, and it could cause a hardship for them as well. So this moves into the hold harmless. The next two things that we're going to cover here is going to be probably the most important thing about a contract that you can get with your client. The hold harmless, okay, this protects yourself. And what it does, it explains a good faith clause in there. So if you're acting in good faith for somebody and they're saying, hey, I need you to go check on, my bestie. I haven't heard from my bestie for such a long time. I want you to go check on them. Well, the first thing you should be doing first and foremost, okay, especially if they want like addresses or something, is conduct a background check on your client. Because if there is a protection order in place, or if there's something that they're not supposed to be around that individual, your butt can get hurt on this, and a lot of stuff comes into play. So always use due diligence and check for that first. If you don't find anything, make a copy of your report and put it in the case file that's dated and timestamped, because if something changes and all of a sudden they get served and you did this out of good faith, but they got served the same day, you can cover yourself and, and let, any, the proper authorities know, look, they didn't have this at the time that I checked on them, and they got served after the contract was signed. I wasn't notified. Therefore, the hold harmless, the client takes on the responsibility because they should have notified you of what had happened here. So again, that's damages and losses for like court fines and fees, legal conflicts, lawyers. This will help you in most cases when this does happen. And again, have the client initial it. If they're in your office, verify that they're signing it in front, initially it, make sure they are who they say they are, and don't be afraid to ask them for ID if you are questionable whether or not they are who they say they are. Especially if you're going to take payments from them, always check their ID so you know if they're not using somebody else's credit card. The second thing, like I said, that was also important is confidentiality. This protects yourself and the client. All right. You got to give an acknowledgement out there that you may come across information that's not going to be public access. So you need to let the client know that confidentiality is a high priority. Matt, do you go over this verbal with the client? Yes, Claire, I do go over that verbally. When I have the client, if they're on the phone with me or if they're in person. Whenever I send a contract, if it's somebody from out of state, especially, I make sure they receive the contract. I have them go through the contract while I'm on the phone with them, if at all possible. That way I explain it to them, and I do record my calls, and I let them know that the call is recorded if it's in a state that's a two-party state. Otherwise, I have them in my office most of the time, and I'm going through the contract step by step. So not a problem, Claire. So going back into the confidentiality, you got to explain the protection to them. Okay, this is extremely important because you got to let them know the only way that you'll release information about the case is if they give you consent, and again, you want it written. Their consent can be, emailed, texted to you from a number is theirs, even verbally to you. Just make sure you record a verbal statement from them that they give you consent to share it with certain individuals, or except as required by law, which would be like subpoenas and stuff like that. If you get subpoenaed by the court, you got to provide the information, and your client needs to understand that a subpoena supersedes a lot of stuff in this scenario. Now, it doesn't mean give the whole case file up to the subpoena. Only provide what the subpoena asks for. If they ask, we need the dates and times, give them the dates and times. If they ask for just videos but no photographs, give them just the videos, no photographs. Whatever the subpoena says, don't overdo it, because remember, again, you're protecting yourself and your client. And the worst thing to go is to overproduce items on a subpoena, and have your personal notes where you're calling the subject names or something, or making comments on notes and scratching it out. That can be used against you to be biased. But we're not going into that. That's another class, how to do that stuff, that we could probably arrange as well. But again, consent of the client, and unless it's required by law, confidentiality is always a must. And it's optional if you want the client to initial that or not. I usually don't, because I do explain it to them, and it's written there plain as day. So again, the client initial is optional. If you feel that they're going to need it, then get that client initial on there. Now, another big thing with the contract, a lot of people have issues with, we cannot guarantee the outcome of any case whatsoever. Clients want guarantees. Well, guess what? Have it in your contract. There is never a guarantee. There's no guarantee. Because if you guarantee them something and you don't produce, you could be held legally liable for anything from fees to everything else. And if you put a guarantee in your contract, that voids any hold harmless, that voids anything else because you have negligence on your part for not producing what you guaranteed to them. So you want to let them know to expect the variable and external factors. So in my case, on my contract, I always put in there, I cannot guarantee the anticipated outcomes of the investigation due to the nature of the job and various external factors beyond its control. We can't go knock on a door and tell a subject, I need you to come out and start mowing your yard because I know that, you have an insurance claim. You can't do that. If they don't come out of their house, you're getting paid for being there. Be there, watch for them. There's nothing we can do to make them do it. Now, this is optional for you. One of the things is when we get clients that are not happy, okay, they come up with a lot of excuses why they're not happy. They come up with a lot of reasons why, and they like to express their unhappiness. Put in a clause in there to prevent negative reviews. All right. In this case, a negative review of the company is not warranted solely based on services that were conducted, but did not yield favorable or anticipated outcomes. Now, if you're negligent, yes, it warrants it. But if they didn't get the outcome that they want, this protects you. So if they go on Yelp, if they go on Google, and they go on, wherever they go to make a review against you, if they initial this section and you send that contract to the proper people and chain when you file a complaint, they will remove that review if you did nothing wrong. But if it was negligent on your part, it'll stay. So always let the client know you can't guarantee the outcome of an investigation and have it in writing. So if once they initial it, they are under the understanding as well as you're explaining it to them. Now we're getting into the finalization of the agreement here. Finalizing the agreement, all right, in these three things, okay, you want to explain that the agreement can be terminated, but it's going to require a written notice from the other party, okay, or to the other party, I should say. Termination shall be effective upon receipt of the written notice. So if somebody sends you a text message says, hey, stop all surveillance or stop the investigation, or I've got enough, let's go ahead and close the case out. Stop what you're doing, and that's a termination of the contract. They are ceasing the contract unless you ask them, okay, do you want it to be put on hold? That's a different thing. You could still maintain the contract, work with them, just give them a time frame as to how long the contract will still be valid. So if you say, look, I'll keep the contract open for 3 months, get it in text or an email to them and put it in there. I just need you to agree to this. Have them agree. You don't have to do another contract. You could just add to the contract as you need it, or like add other agreements that they want to do. Then, of course, governing law, whatever state you're in this case, I'm in Idaho, so the contract shall be governed by and construed in accordance with the laws of the state of Idaho without regard to its conflict of law principles. So this contract is binding as long as they sign it and you sign it. Okay, it is binding with everything that's stipulated within. And then you have the entire agreement. You want to make sure that they understand that this entire agreement, everything in here, is exactly what you're going to be doing for them for the work that they're asking you to do. So you want to put it in there, however legal words that you want to put it in there also that the provisions of private investigation services, again, you let them know it's private investigation services, not we're going to go out there and check every day, or, I'm not going to go mow your yard or anything. These are private investigation services, and it supersedes any prior agreements or understanding, whether written or oral, relating to the subject matter herein. So this contract is what you go on, especially if they text you and they say, hey, I need you to go and can you run this plate, or can you go out and just take a picture? Sure, we can do that, but it's still underneath the contract. And again, have the client initial these sections. You could put a section in there for them to initial. And as long as that's there, you're going to protect yourself. Now, the last thing on a contract, obviously, it's going to be void unless you start obtaining signatures. The client will always sign first, you will sign last, and provide copies of the contract to the client. Never give them the original contract. All right, you keep the original, you give them the copy. Straight and simple, down to the point. Once they sign it, you date it, you're there, you put your seal of approval on it. It's a contract between the two of you. You do not need to have a witness, you don't need to have a notary, and this will be here for you at the end of the contract. And make sure that when they're signing below, you have a tidbit in there, such as mine, okay, or however you want to word it. But please sign below to indicate your acceptance of the terms and conditions outlined in this contract. A signed copy of this contract shall be retained by both parties. So again, it goes with them. And at the end, of course, thank them if you want to. If you want to bring it, put a little nice word down there for them, you're more than welcome to. But with that being said, this actually concludes the presentation. Like I told you, 40, maybe 45 minutes. But does anybody have any questions for me?
I have a question. Are you going to share with me, or can you? I want to make sure that everyone here on the phone, on the conference, gets a copy of that template.
Yeah, I can absolutely do that. And again, it is just a template. All right, I have PDF and Word variants of it. Let me see here. And something, yeah, if you give me just a second, since I'm still sharing the screen, let me do something here. Oh, hold on, we have a question. Make sure I have email. Yes. So let's make sure that we do get the emails in if you guys are interested in a template. But I do want to show you something, so bear with me. So I use Adobe a lot. And one thing, if you set it up appropriately, all right, you should be able to set up a contract where everything you fill in will automatically sum up totals. It'll automatically, fill things in it. And I can help people with that too, with the guide. Let me see here, bear with me. All right, so Adobe, I don't know what you guys use for contracts, but let's see. I'm just going to go ahead and send it to myself, but I'm just going to show you something here. I'll do. All right, so when I do my agreement, this is overall what it'll look like if you do it through Adobe, and I definitely recommend it because it'll help you set things up appropriately. Now, I have fields set in here that as I progress, give me a second. Okay, I could start putting the client's name in. So, okay, and whatever the address is, it's automatically starting to put it down towards the bottom as well. And and this is the actual contract that I have, just so you guys kind of see it. Literally is 2.5 pages. And with Adobe, I have found that whatever it is you do, you can have everything, self fill out. Like right now, okay, it's 850. If I want, 85 an hour, and instead they wanted 4 hours, hypothetically, it's going to put the correct price up there, making things easy for you. And, whatever contracts you have now, if it works for you, great. Nobody's expecting you to change up on it unless you want to. All right. And contracts are very important with our line of business, especially if you want to protect yourself. And especially since we do it for profit. If somebody tells me flat out, hey, I don't do this for profit, I do it because of the love of the game. Okay, I can understand that, but you're still making that car payment, you're still doing other things. And as long as you got it stipulated in here, you shouldn't have an issue with any legal repercussions or anything like that too. And I'm not saying this is the only thing that needs to be in a contract, but this is a shortened, condensed contract that lays it out simple for clients, and it helps them to understand fully that, this is what they're going to get, straight and simple. If you have other stuff in there, that's awesome. The more you have, for you, if you're comfortable with it, go for it. But again, like I said, I went from a 14-page contract. I thought I needed all the extra fluff. It got narrowed down to 7 pages and narrowed down to 2.5. And it does hold up. If you ever have a chargeback, it'll hold up. If you have a dispute resolution, this will hold up. Whatever the case is, this contract will be what you'll want to get there. And then when you fill everything in, you can always print it out if you have a client in front of you. You submit this, you send it, and then you print it out and have them sign it in front of you. Or even if it's digitally, when they sign it, it'll be time-stamped, dated, and everything as well. And that is also utilized efficiently for the courts as well. Are there any other questions?
I just want to tell everyone that I did in the chat, ask everyone if you want a copy of this to please make sure I have your email so that I can get it off to you. And also Matt's entire presentation will be posted on our website. But I can also, obviously send it to you if I have your individual email.
But yeah, Pat, I'll send you a full-on template
Great.
that you can pass out for them, and I'll remove my information to make it easy for them. But that's if you want to use it, customize it, do whatever you want. It's your business. And, I just find that 2.5 pages is better than having to go through page by page by page and just lay it out for somebody, as simple in some cases. Some contracts may need to be longer. Again, it's all specific to you as an individual, as your own company.
Oh, so helpful, Matt. Thank you, thank you, thank you. I really got a lot out of it. I'm going to take my retainer agreement and dispose of it and use yours.
Well, people don't think that you can put a non-refundable clause in there, but you can if you explain why, and nothing worse than, being somewhere. And I'm not saying go for the non-refundable, stick with what works for you and your clients. But I have not had a problem with clients doing the non-refundable because they understand.
Right. All right. Well, I think if there's no more questions, we can say thank you to Matt. And I look forward to seeing everyone on our next webinar. And you probably already know this, but we have a new chairman of the Education and Training Committee, Claire Royce, and she's got a lot of things on the docket. So you'll be hearing from us.
Good to go.
Okay.
Thank you, everybody, for coming on.
Thank you. Bye-bye.